Welcome to today's program titled The Future of the Klein Conspiracy Doctrine. Is its demise imminent? All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Rich Morvillo. Rich, you may begin.
Thank you. Good afternoon, everybody. I hope you're well. We're going to talk to you today about 18 U.S.C. Section 371, and we'll try to make it interesting. I'm joined in my discussion by my colleagues, who you can see, Ellen Murphy, who is a member of our White Collar Defense and Investigations Group, and Scott Morvillo, who with me co-chairs the group. We're going to talk about the background of so-called Klein conspiracies, and we're going to get into how this mess was created in the first place. And then we're going to talk about a variety of prosecutions that the government has brought under Section 371 to give you an idea of how broadly the government interprets its mandate under the statute. And finally, Ellen is going to talk about an issue of some interest to all of us, which is the possibility that this Supreme Court will have an opportunity to weigh in on the continued viability of so-called Klein conspiracies. There is a case pending in the Second Circuit, which is going to be argued in June of this year, a tax-related case, which may invite further scrutiny from the Second Circuit as well as from the Supreme Court itself. And we'll get into the reasons for our optimism on that in that regard when Ellen gets to speak. So let me jump in and talk about statutory context of Section 371. 371 prohibits two different types of conduct. The statute makes it a crime for two or more persons to conspire to commit an offense against the United States or to defraud the United States or any agency thereof by any means or for any purpose. So the language is fairly broad. As it's written in the disjunctive, as I said, it involves two separate crimes, and it has been interpreted under two separate clauses. The so-called offense clause, the first clause, which makes it unlawful to conspire to commit an offense. And that simply means if you conspire to commit a substantive crime under the United States Criminal Code, you have committed an independent crime of conspiracy under Section 371. So those who engage in bank fraud, for example, when they conspire to do so, will also be chargeable with conspiracy to commit an offense under Section 371. The second part of the statute deals with the to defraud clause. That is broader and consequently somewhat more controversial. It simply makes it a crime to conspire to commit fraud against the United States. It doesn't require a violation of any other statute. It is a violation standing on its own. The problem with it is that Congress has never stopped to define what it means to defraud the United States. And so it has left it to the courts to decipher that phrase. Now, let me stop there to say for a second that under rules of statutory construction, when Congress uses terms that have a well-accepted meaning in the common law, the courts are to infer that Congress meant, absent some indication otherwise, to incorporate that same definition into the statute. So, well, by using the term to defraud in section 371, we look to the common law to determine what it means to defraud. And what you'll hear in a discussion that I'll give and that Scott will give is that the courts have not been faithful to deciphering the term to defraud consistent with the common law, and hence there is at least an argument that the textual statute is ungrounded. Text of the statute is ungrounded in its current interpretation. So let me start by telling you there are three elements to a conspiracy to defraud under section 371. The first is an agreement to defraud the United States. The second is knowledge of the agreement and voluntarily joining the conspiracy. The third is an overt act in furtherance of the conspiracy. Conspiracies, most criminal defense lawyers will tell you, are somewhat easier for the government to prove than the underlying violation. The underlying statute that's violated has its own elements, which are oftentimes fairly exacting. A conspiracy case is made more often than not in proof of the existence of the agreement and the one or more overt acts, whether or not they may constitute a full-blown offense is often debatable. But if you can establish the agreement and you can establish the overt acts, then you can establish conspiracy. As a consequence, the government often charges conspiracies in lieu of or in addition to the underlying violation. So it would be common to see an indictment that charges wire fraud, substantive violation, coupled with a conspiracy to commit wire fraud. Historically, the Supreme Court has interpreted Section 371 broadly. But as Ellen will do for you, if you look at its roots, you begin to wonder or not whether the Supreme Court, as currently constituted, will see that there are holes in the statutory interpretation and cut back on the existence of 371 conspiracies. The Klein conspiracy doctrine is, after all, based on dicta from a Supreme Court case that's over 100 years old. In Haas versus Hinckley, the government charged the statistician with conspiring with future traders to provide information about cotton crop reports issued by the Department of Agriculture. The government said that divulging that information deprived the reports of their value, and it also undermined the functions of the Department of Agriculture. Interestingly, the court said that the disclosure of the information did devalue the reports and therefore satisfied the financial loss requirement of the statute, which is interesting, and I'll stop there for a second, because that in and of itself suggested that there was a financial loss requirement of the statute. The court could have stopped when it found that, but it decided to go on and issue dicta with regard to the sweep of the statutory language. It said in dicta, did not hold. It said in dicta that the term was broad enough to include any conspiracy defeating, impairing, or obstructing the lawful function of any department or agency of the government. Though it was dicta, the government latched on to the Haas language in a case called Hammerschmidt, which was decided years later, a case involving 13 defendants who were convicted of conspiring to defraud the government by reason of their open defiance of the draft. Interestingly, when the Supreme Court got around to reviewing the case, it held that the defendants did not violate Section 371 because there was no deceit proved as part of the cost as part of the fraud. Therefore, the court reversed the convictions. It again could have stopped there, but the court went on and discussed further the fraud clause. It said that the court of the United States can go forward where the fraud is simply cheating the United States government out of money or property, or again, utilizing the words interfere with or obstruct with a lawful government function by trickery, deceit, and dishonest means. So you've got two cases back to back, those years apart, which interpret the defraud clause very broadly in the context of Section 371. Now, as Ellen will tell you when we get into it, that seems to be at odds with the current thinking of the Supreme Court in terms of what constitutes fraud. In the McNally case that Ellen will probably touch on, the court defined the words to defraud to commonly refer to wrongdoing in one's property rights by dishonest means. And so you've added into the defraud context the common law notion of loss of property. But I'm going to now turn it over to Scott to discuss how, let me first discuss Klein, and then I'll turn it over to Scott to discuss how the Klein conspiracy doctrine has been utilized in subsequent years. Klein came up about 30 years later, and it involved a case of tax evasion and conspiracy, where the defendants had created corporations and entities in different jurisdictions and had, as a consequence, been able to conceal their income. Interestingly, at trial, they were acquitted of their tax evasion charges, but they were convicted of the conspiracy count. On appeal, the defendants raised the issue that there was a textual basis for the Klein conspiracy, that the words to impair and to impede a lawful government functions nowhere appear in the statute, and that it was nothing more than another manifestation of the old common law notion that fraud involves a diminution or wronging with regard to property rights. In affirming the convictions in 1957, the Second Circuit turned dicta from Haas and Haberschmidt into doctrine. Relying on Haberschmidt, it held that the defraud clause not only prohibits cheating the government out of money property, but also the impairment or defeating of a lawful government function, as long as it's done by deceit or dishonest means. So now, with that background, Klein conspiracies have since 1957 been tools that the prosecution has utilized to prosecute different kinds of crimes. And I'm going to turn it over to Scott now, who will be able to give you some stories about how far the government has gone in utilizing Klein conspiracy. Scott?
All right. Thanks, Rich. That's a helpful recap of the history of Klein. And so what I want to do from there is to go from the middle of last century to basically to the present, but I need to go there in steps. And what I need to do is, what we'd like to do is to go through the different types of conduct where we see the government charge Klein conspiracies, to get an understanding of just how broadly the fraud clause has been interpreted. So specifically, I'm going to talk about the impair, interfere with, or obstruct one of the lawful functions of the federal government or any department thereof aspect of Klein conspiracies. Now, we know from Rich's discussion that several of the Klein conspiracies involved IRS offenses. And to that point, in United States versus Copeland, which Rich is going to be discussing later, and which I think many others think may have been the beginning of the end of the Klein doctrine, We'll see. But in that case, the Second Circuit noted that 371 was originally enacted as a measure relating to internal revenue. And interestingly, despite the view that I may hold and the view of many, that including the members of this panel, that the Klein Doctrine is at risk being overturned, the current DOJ criminal tax manual discusses the Klein conspiracy and conspiracies at length. 20 pages, 30 pages of the criminal tax manual discusses Klein conspiracies, which is interesting. Likewise, the criminal investigation section of the current IRS website discusses Klein conspiracies and notes that the defraud clause is very broad and encompasses a vast array of conduct, including acts that do not constitute a crime under a separate federal statute. So what does that all mean? Well, essentially, the interpretation of defraud in the interfere with or obstruct context means that the government can charge Klein conspiracies in a wide variety of matters beyond IRS cases. So in other words, as usual, the DOJ could do whatever they want to do and basically fall back on Klein. Now, that's a little bit cynical and maybe a little bit dramatic, but you know, I'm a criminal defense lawyer, so I need to take my shots at the DOJ when I can. But the truth is that all the government has to do is find some evidence that someone has undermined the integrity of a governmental program or the policies of the United States or one of its agencies, and they can use Klein as the basis to initiate a case, which really means that Klein could be an important tool for implementing or effectuating the DOJ's agenda. And the DOJ has used Klein beyond IRS cases in the past. Klein prosecutions have included the filing of false statements to a government agency, including the INS, which is quite topical these days, so we may return to that if we have enough time, the misuse of confidential government information and in public corruption cases, to name a few. So it'll be interesting to see what this DOJ does with respect to Klein and how broadly they want to interpret Klein and how they want to use it going forward during the current administration. Okay, so with that background about how broad Klein is, I'd like to start off where Rich left off and discuss the Supreme Court case of Demise versus United States. Demise is a 1966 decision, and it's an important case because it's the case where the Second Circuit relied upon as precedent for its ruling in Copeland. It was decided a little less than a decade after Klein, and Demise dealt with the issue of whether an indictment properly charged a conspiracy to defraud the United States under 371. Demise involved several individuals convicted of under 371 for conspiring to fraudulently obtain the services of the National Labor Relations Board, on the NLRB, on behalf of some union workers by filing false affidavits swearing that these workers were not members of the Communist Party. The union then utilized the NLRB services, a privilege obtained by the use of these defendants' fraudulent acts. The Supreme Court granted cert to address three issues, and one of which was whether the indictment alleged a conspiracy to defraud the U.S. under 371. Now, the petitioners argued that their conduct could not be considered fraudulent under 371 because the NLRB was required to certify compliance of any union whose officers filed non-communist affidavits, without regard to the veracity of those affidavits. And since the NLRB services were not predicated on the truthfulness of those affidavits, the element of reliance was missing, and thus there was no conspiracy to defraud. The court, remembering that this was in the thick of the communist drama in the United States, the court rejected their arguments and found that the indictment properly alleged that petitioners and their co-conspirators could not have obtained the NLRB's services without filing these non-communist affidavits. The affidavits were submitted as part of a scheme to induce the NLRB to act. The NLRB did, in fact, act in reliance upon the fact that those affidavits were filed, and the affidavits were false. And therefore, the court held this conduct fell within the meaning of Section 371 to defraud the United States government or an agency thereof, the NLRB. The petitioners also argued that the case did not involve a conspiracy to defraud but rather a conspiracy to commit the substantive underlying offense of filing false statements in violation of Title 18 U.S. Code 1001, and that a conspiracy to file false statements is not proper under the defraud clause of Section 371. The court rejected this argument as well. It reasoned that the conspiracy to defraud properly reflected the essence of the alleged offense, and that the conduct of filing false statements did not, in and of itself, make the conspiracy to defraud clause of Section 371 unavailable to prosecution. So you can have, both. You can charge the 18 U.S.C. 1001 as well as the 371 charge. In sum, what the Dennis court did was it endorsed a very broad interpretation of this defraud clause I've been talking about. It held that the statutory language of 371 is not confined to fraud as the term has been defined in common law. It reaches any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of the government. So that's Dennis, and that's like I said, that's an important case because that's what Copeland relies on in 2000 in the mid 2000s. So let me jump ahead several decades to 1996 and discuss U.S. v. Balestria, and that's a 1996 Second Circuit case. And in that case, the Second Circuit considered whether the defendant could be convicted of defrauding an agency of the U.S. under 371, even if it did not contact agency personnel or submit documents to the agency. So the defendant in Balestria was basically at the top of a distribution network called Life Energy Resources, or LER for short. And LER marketed and sold a variety of health-related devices and products through a multi-level marketing network. Now, two of the products that they sold were marketed as having certain medicinal effects, such as curing cancer, staph infections, and other serious illnesses. Balestria himself personally told potential purchasers of their products, including several of them who were gravely ill or had sick relatives, and people that were desperate, about these alleged curative powers of these products that he was selling. The defendant, knowing that these products were not FDA approved, sought to conceal his activities and the activities of others at LER from the government. Specifically, the distributorship agreement explicitly forbade LER distributors from making medicinal claims about LER products or using unofficial literature to tout the curative products of, the curative powers of LER products. In addition, Balestria and one of his co-defendants told an undercover government agents who were posing as downstream distributors for LER that while they should use unofficial literature to market these products, especially to customers who were ill, they should take great care to ensure that the use of this information was not discovered by the FDA. So real nice guys here taking advantage of these people. But they didn't stop there. Balestria stated in a training video on an LER phone operators that they should be careful about touting these LER products as medicinal aids or medical aids to callers because it could be the FDA calling them. And on top of that, Balestria informed a separate undercover postal inspector that he helped to set up a new company to distribute the products because he was concerned that the FDA was acting against LER and its distributors for improperly distributing these products. So he was moving on to a different company to engage in the same conduct. So you will not be surprised to know that Balestria and his co-defendants were convicted. On appeal, he argued that the conspiracy to defraud the government charge should not stand because that required the element of obstruction or interference, which must involve actual contact between he, or the defendant, and the government agency. For instance, through making misrepresentations to the agency, the FDA, or FDA officials, or submitting false information to the agency. The Second Circuit rejected that argument, concluding that Balestria was properly convicted of the conspiracy to defraud the FDA because he conspired with others to interfere with or obstruct the FDA's lawful function of regulating interstate distribution of medical devices and drugs, and he did so by deceit, trickery, and dishonest means. The Second Circuit also recognized that defrauding under 371 had been construed more broadly than other statutes, making it possible to sustain this conviction under 371, even though Balestria and his co-defendants had no contact and submitted no papers to the FDA, the U.S. agency in question. So again, Second Circuit focuses on this broad definition of defraud under 371. So that's the 1990s. I want to jump ahead to the United States versus Stewart case, which was in 2009, so moving into a post 9/11 world. And this case involved a defense attorney representing an alleged terrorist, and this defense attorney was convicted of conspiring to defraud the government. Like I said, the name of the case is called United States versus Stewart. This is the Lynn Stewart case, which is not to be confused with the Martha Stewart case, which is also an interesting case, somewhat irrelevant, I think, for our discussion today, although I think it's possible we come back to the Martha Stewart case as well, depending on how much time we have. Anyway, in 2003, the government filed charges against Lynn Stewart for, among other things, conspiracy to defraud the government, specifically the Department of Justice and the Bureau of Prisons, the BOP, in the administration and enforcement of special administrative measures, SAMs, S-A-M-S, that were put in place for her client. Her client was Sheikh Omar Abdel Rahman, and I will go over those SAMs in a second, but Stewart represented the Sheikh, who many of you may recall was a blind cleric that was charged in Southern District with terrorism-related conduct. It included seditious conspiracy, solicitation of murder, solicitation of an attack on American military installations, conspiracy to bomb. So in order to speak to her client, the Sheikh, Lynn Stewart had to agree to these SAMs that the government had put in place, given the nature of the case. And remember, this is sort of post 9/11. So the indictment against Stewart, the prosecutors, which sort of fun fact for me, included my brother Chris, alleged that Stewart conspired with others to defraud the United States, specifically by passing messages from her client to others in violations of these SAMs. So you see, when Stewart signed this affirmation agreeing to abide by the SAMs, she basically agreed that when she was visiting her client, the Sheikh, she would only be accompanied by a translator for the purpose of communicating with the Sheikh concerning legal matters. The Sheikh spoke Arabic, I think, and but didn't speak English in any event, and Lynn Stewart didn't speak Arabic, so she needed a translator. And as part of these SAMs, she would not use these meetings or correspondence or phone calls with the Sheikh to pass messages to third parties. So she signed an affirmation saying she wouldn't do that. She lied, and she passed messages to third parties from the Sheikh. If I recall correctly, she even brought one of Sheikh Abdul Rahman's associates with her to visit the Sheikh in jail. He posed as an interpreter, which is why he was able to accompany Lynn Stewart, and that enabled the Sheikh to pass along messages to this associate and from there to others. Following an 11-month trial, Stewart was convicted of, among other things, conspiracy to defraud the U.S. by violating these SAMs. Now, on appeal, she argued that the evidence was insufficient to support a 371 conviction by obstructing the DOJ and BOP in connection with the administration and enforcement of these SAMs. And she specifically argued that her defiance of the SAMs were open and not deceitful, and that she acted with the intent to zealously represent her client and not to defraud the United States. there is a story about Lynn going to the, I think the MDC or the MCC meeting with, which is the Metropolitan Detention Center or Correctional Center near the Southern District, and she would visit him with this interpreter. The interpreter was not an actual interpreter, but was one of the Sheikh's associates. And while the Sheikh and his associate were speaking, Lynn would sing songs and make noises and pretend that she was participating in these conversations with the Sheikh and his associate in an effort to make sure that the BOP was, seeing that she was participating in these conversations, because if it was just a one-on-one conversation between the Sheikh and his associate, the BOP may have stopped those sessions and kicked them out. But also there was a thought that the BOP might be taping these conversations, and so she was singing and making all sorts of noises so that she could impact the quality of the video and of the recording, so that even if the BOP was listening, they couldn't hear what the Sheikh and his associate were doing. So that was sort of open what she was doing, at least in her view. The Second Circuit disagreed and rejected her argument. It found that a reasonable jury could have found that she gained access to a client by deceit and dishonest means, because without her agreement to abide by these SAMs, she would not have been allowed to visit the Sheikh, and therefore would not been able to defy those regulations openly and publicize messages on his behalf. Excuse me. She also argued that her intent was not to defraud the government, but to zealously represent her client. The Second Circuit rejected that argument as well, finding that the jury had a reasonable basis to believe that such a zealous representation would not include filing false affirmations, hiding stuff from prison guards, the delivery of messages to Rahman, and the dissemination of his responses by him, and all of that were obtained through her dishonesty. So that was an interesting case, but brings me to the last case I want to talk about, which is a 2018 case, United States versus Middendorf. And that's a case where several KPMG employees were indicted for, among other things, conspiring to improve KPMG's performance on inspections conducted by the PCAOB by passing confidential PCAOB information to select KPMG employees. They filed a motion to dismiss the indictment and argued that the indictment failed to allege the purpose of the conspiracy was to obstruct the lawful function of the government agency, because the PCAOB is not a government agency, and that the indictment failed to allege that the defendants agreed to use deceitful or dishonest means to defraud the government, because it did not allege affirmative misrepresentations to the government or breach of duty owed to the government. The district court rejected the defendant's first argument, relying on the fact that the indictment alleged that the defendants knew that their scheme would alter PCAOB inspection results, which would then be reported to the SEC, which is a part of the government and a regulatory body of the government. And that would affect the SEC's regulatory and enforcement functions and was part and parcel of the scheme. And so the court held that the indictment sufficiently alleged the defendants conspired to obstruct the government agency. As the second argument, the court, citing Balestrita, which I just talked about, said it was bound by the Second Circuit and that a conspiracy to defraud includes a scheme to obstruct the law through deceit, trickery, and dishonest means. And so it affirmed on the second point as well. Interestingly, the jury acquitted defendants Middendorf and one of his co-defendants on the 371 charges, and ultimately all the defendants' convictions were vacated or overturned based upon Second Circuit's 2022 decision in a case that Ellen will talk about in a minute, and I can't pronounce the name, Laszak or whatever. In any event, what I find interesting about this case is that the district judge's term that he termed that he was bound by Second Circuit precedent. So perhaps this judge was not really sold on the Klein doctrine, which I think is a good transition back to Rich for him to discuss Copeland. Rich, you're on mute.
Thank you, Scott. Copeland is a case that came to the Second Circuit about a decade ago. Not to pick on CPAs, but it involved 4 partners at a Big 4 tax and accounting firm who were accused of tax evasion and conspiracy to defraud the government. And the charges stem from the defendant's involvement in marketing 5 different abusive tax shelters. They are alleged to have concealed the true nature of those tax shelters by creating cover stories for their clients' legitimate business reasons and entering into those tax shelters. They were convicted. On appeal, the defendants again argued that there was no textual support in the defraud clause. Again, the statute doesn't mention the words impeding or impairing a government function. And they asserted that without more, the government was now able to prosecute people simply for impairing or impeding a function, whatever that meant. They implied that it was not fraud to suggest that it is that engaging in fraudulent activity that makes it harder for the government to do its job is sufficient under the common law to constitute fraud. Lending further support to the idea that Klein conspiracies are textually unfounded, the Second Circuit noted that Klein conspiracies are a creature of the courts. They're a common law offense. And it went on to say that as a result of this alone, that the doctrine requires some considerable judicial skepticism. It found the government's brief lacking. The government relied on the Hammerschmidt Dennis interpretation of Section 371 as its argument for statutory construction. The court said, and I quote, "There is nothing in the government's brief recognizable as statutory interpretation. No discussion of plain meaning, legislative history, or interpretive canons." The same is true of Hammerschmidt and the other Supreme Court cases that we've been discussing. They don't go into how you construe a common law term of to defraud to include impairing and impeding. So it looked pretty good for the defendants in the case, and the Second Circuit seemed to be persuaded by the arguments that there's no rooting in the common law antecedents, and so there was some optimism. But the court found that it was duty bound to abide by Supreme Court precedent and upheld the convictions. Though I think 2 of them were overturned for lack of sufficiency of evidence, but the theory itself was sustained. The Second Circuit invited the defendants to seek to bring the matter up to a quote higher authority, obviously the Supreme Court. The defendants filed a cert petition, teeing up the issue. The Supreme Court denied cert, and so at least for now, there is reason to believe that the Klein doctrine survives alive, if not well, in the Second Circuit. And as I mentioned, there is a case that may bring it back to the fore at the Second Circuit that we'll touch on if time permits. But right now, I'm going to turn it over to Ellen, who can try to explain to you why our view is that the Supreme Court is likely to overturn the Klein conspiracy.
Thanks, Rich. So prior to the Second Circuit's opinion in Copeland, courts had really been surprisingly uncritical of the extension of the defraud prong of the conspiracy statute. There was one exception, a case in 1993 in the Ninth Circuit, United States versus Caldwell, in which the Court of Appeals reversed the conviction of a bookkeeper for a warehouse bank, a bank that used numbered accounts and promised to keep no records of client transactions and vowed to disclose no information about the accounts to third parties. It was the 90s. The bank's goal was to maintain privacy for its clients, but it also helped the bank's customer avoid paying taxes. In the jury instructions at trial, the district court omitted the requirement that the prosecution prove not merely that the conspirators agreed to obstruct a lawful government function, but that they agreed to do so through deceitful or deceptive means. On appeal, the government defended the conviction by arguing that any conspiracy to interfere or impede with government's functioning was unlawful. The Ninth Circuit's opinion began by noting that while the text of 371 seems to cover only defrauding in the normal sense of the word, i.e. acquiring another's property by intentional misrepresentations, that the statute had been read much more broadly. The court opined that the government's theory of the defraud conspiracy was spurious given the broad reach of the statute and its capacity to subject a wide range of activity to potential criminal penalties. The court found that the government's theory would essentially forbid all things that obstruct government or require citizens to do all those things that could make the government's job easier. The lack of criticism of the extension of the defraud prong of the conspiracy statute also stands in stark contrast to other Supreme Court cases limiting the scope of fraud statutes to those, schemes that involve money or property. And so, for example, in 1987, as Rich alluded to before, you had the Supreme Court decide McNally versus the United States, which significantly limited the scope of the federal mail fraud statute with respect to the concept of defrauding. In that case, the scheme involved, the case involved a scheme in which state officials steered insurance contracts to favored agents in return for kickbacks. The government prosecuted under the federal mail fraud statute, arguing the public was defrauded of its right to have the state's affairs conducted honestly. The Supreme Court held that the federal mail fraud statute only protects against schemes to defraud individuals of money or property, not intangible rights such as the right of honest services of public officials. The court focused on the statute's language and the common understanding of the concept of defraud. Interestingly, the Supreme Court cited Hammerschmidt in support for its finding for the proposition that the words to defraud commonly refer to wronging one in his property rights by dishonest methods or schemes, and usually signify the deprivation of something of value by trick, deceit, or overreaching. I would note this is a very different interpretation of the court's opinion in Hammerschmidt than the Second Circuit took in Klein. Similarly, in 2010, the Supreme Court decided Skilling versus the United States, which arose out of Enron's collapse. Jeffrey Skilling, a former Enron executive, was charged with multiple counts of fraud, including conspiracy to commit honest services fraud under 18 U.S.C. 1346. The government argued that Skilling had deprived Enron and its shareholders of his honest services through his involvement in a scheme to inflate the company's financial health. On appeal, Skilling argued that Section 1346 was unconstitutionally vague. The Supreme Court determined that construing the honest services statute to cover only schemes involving bribery and kickbacks prevented it from being unconstitutionally vague. In reaching its decision, the court first looked at the doctrine developed in pre-McNally cases in an effort to ascertain the meaning of the phrase, the intangible right of honest services. And second, to preserve what Congress had certainly intended to cover by the statute, the court pared down that body of precedent to its core. There, the main pre-McNally cases involved fraudulent schemes to deprive another of honest services through bribes and kickbacks supplied by a third party who had not been deceived. The court therefore limited the application of honest services frauds to schemes involving kickbacks and bribes. As Rich noted during the discussion in Copeland, the appellants there relied on Skilling to argue that the Second Circuit had an opportunity to correct the judicial overexpansion of another broadly used criminal statute, here Section 371. There, appellants contended that in Skilling, the case law had not succeeded in clarifying the very general statutory language, which led to the Supreme Court to narrow its application. They further argued that, like the honest services doctrine, the defraud prong of 371 should be paired to its common law core and limited to conspiracies to deprive the government of its property rights through deceptive means, not merely impeding or obstructing government functioning. In more recent years, there have been a series of cases in which the Supreme Court has rejected overbroad readings of federal fraud statutes. In 2020, the Supreme Court decided Kelly versus the United States, the Bridgegate case, right, where two former aides to then Governor Chris Christie realigned traffic lanes across the George Washington Bridge for politically motivated reasons. In defending the conviction of the wire fraud, the government argued that the conduct constituted a scheme to defraud the government of its money or property by commandeering the physical traffic lanes and usurping Port Authority's workers' paid time. The Supreme Court rejected this expansive view of the phrase money or property, finding that the wire fraud statute did not criminalize all acts of dishonesty, but only schemes where property is the object of the fraud. In 2023, the court decided Percoco versus the United States. There, a former New York State government employee allegedly used his influence to benefit a real estate developer in exchange for $35,000. At trial, the court instructed the jury that it could find the defendant, a private citizen, had the duty to provide honest services to the public if he dominated and controlled any governmental business, and if people working in the government actually relied upon him because of a special relationship he had with the government. The Supreme Court rejected this broad interpretation of the statute, stating that it does not have an indeterminate breadth that would sweep in any conception of intangible rights of honest services. The court noted that there have long been individuals who lacked any formal government position, but nevertheless exercised very strong influence over government decisions. The court vacated the conviction because the jury instructions failed to define the statute with sufficient definitiveness that ordinary people could understand what conduct is prohibited, or in a manner that does not encourage arbitrary and discriminatory enforcement. On the same day that it decided Percoco, the court also limited the scope of the federal wire fraud statute in Ciminelli versus the United States. In Ciminelli, the defendants were charged with conspiracy and substantive wire fraud counts arising out of an alleged scheme to rig the bidding process for obtaining certain state-funded construction contracts. At trial, the government relied on the right to control theory and argued that the defendants' bid rigging scheme deprived the nonprofit awarding the government contracts of potentially valuable economic information necessary to make discretionary economic decisions with its property, specifically how to best award the construction contracts. The Supreme Court rejected the right to control theory, stating that it was unmoored from the text of the federal fraud statute, which do not protect intangible interests unconnected to traditional property rights. There, the court concluded that the right to control is not an interest that had long been recognized as property when the wire fraud statute was enacted. And because the theory treats mere information as protected interest, it impermissibly makes a federal crime of an almost limitless variety of deceptive actions and vastly expands federal jurisdiction without statutory authority. With respect to cases dealing directly with Section 371, we have United States versus Blazak, which I have no idea if that's how you pronounce the name or not either. Apologies if I'm incorrect. In Blazak, the government charged several individuals with wire fraud, Title 18 securities fraud, conversion, Title 15 securities fraud, and Klein conspiracies under Section 371. Defendant Blazak was a political intelligence consultant for hedge funds and obtained non-public CMS information from former colleagues who still worked at CMS about prospective changes in Medicare reimbursement rates. He disclosed the same to two of his hedge fund clients, who then traded on it. The case has a long and convoluted procedural history, but after a month-long trial, the jury returned a split verdict, acquitting all of the defendants of the Title 15 securities fraud counts. The jury convicted all the defendants except the source of the non-public CMS information of the 371 conspiracy charged in Count 1, and only defendant Blazak of the 371 conspiracy to defraud the government charged in Count 17. The Second Circuit upheld the defendants' convictions. The Supreme Court granted cert and vacated the Second Circuit's decision and remanded in light of its decision in Kelly, the Bridgegate case. On remand, the government and defense agreed that in light of Kelly, the substantive accounts of conviction could stand, but that due to the Kelly holding in a case involving confidential government information, that information typically must have economic value in the hands of the relevant government entity to constitute property for purposes of wire fraud or securities fraud. With respect to the 371 conspiracy charges, however, the government argued that those convictions should stand because defendants' objectives were not only to convert government property, but also to commit Title 15 securities fraud and to defraud the U.S. in violation of 371. The defendants' conspiracy conviction, with respect to the defendants' conspiracy convictions, the court determined that because the jury never was given a question to answer that would reveal which one or more of the alleged conspiratorial goals it had found that the government proved, reversal was required because the jury could have made its determination based on its belief that the Blaze Act defendants conspired to commit a property crime. But by the same token, it could have decided that they were guilty of conspiring to commit a non-property crime. Therefore, the court reversed and remanded those charges for further proceedings, which could potentially have included a new trial. Ultimately, on remand, the parties reached a resolution, and so we've been deprived of yet another opportunity to challenge Section 371. Which brings us now to the current state of affairs and the case currently pending in the Second Circuit, the Lingette case, which Scott is going to tell you about now.
Well, thanks, Ellen. So Lingette involves some people that worked at Moishe's moving company, and they were charged with conspiring to defraud the government, specifically the IRS, by creating sham companies that employed laborers working at the direction of Moishe's with the intent to defraud the IRS out of payroll and income taxes. Lingette, as it turns out, was the head accountant at Moishe's Moving. After trial, the defendants moved for a judgment of acquittal, arguing that the sole 371 charge, conspiracy charge, could not stand because the indictment did not also charge them with the underlying substantive crime of payroll tax evasion. The defendants in Lingette relied on the dicta in Copeland, particularly with respect to the expansive reading of 371. They argued that Copeland and the series of Supreme Court cases that's paring down each of the other federal statutes that Ellen had just discussed have undermined the Klein Doctrine. The district court rejected the defendant's argument to ignore the clear holding of Copeland in favor of mere dicta. So that court is now currently on appeal, as Rich and Ellen mentioned. The briefs have been filed. The oral argument is scheduled for the week of June 23rd. So we'll see what happens with that case and whether or not this is the right case for the Second Circuit, or they're going to use another case to decide Klein later on. And who knows what happens with the Second Circuit, whether or not the Supreme Court will grant cert if one or the other side decides to take it up. Rich? You're on mute again.
Trying to be so good not to interfere with you. Sorry. As you can tell, the government has utilized the Klein conspiracies in a number of ways, but you got to look back at the beginning and analyze the way in which the courts have approached the term to defraud. As Ellen has suggested, in recent cases, the court has been cutting back on the notion of fraud in the wire fraud and the mail fraud and other statutory contexts, and looks as though it may be prepared to take a harder look at whether or not Section 371, based as it is in dicta, is actually the correct result. It's interesting because Copeland did hold that it's a viable doctrine, but it's all coming from dicta without any attempt to analyze from a statutory construction point of view, the correct approach to the common law notion of fraud. So when you look, and I'm going to ask a question or two if I can, but if you look at some of the cases that have been decided, you begin to wonder how far the government will go. So, for example, in an insider trading case involving tippers, there is a notion that the tipper must receive a personal benefit from providing the tip under under 15 U.S. Code provisions, 78 JB. But when you look at the notion that you can conspire to defraud without depriving somebody of property or or pecuniary loss, you begin to say, is the mere act of making it more difficult for the government to uncover the crime in and of itself sufficient to charge them with disrupting or impeding a government function? So take the insider trading case that involves trading in options, or the insider trading case that involves multiple accounts used in various countries to affect the trades. I worry that the government may be able to parlay conspiracy theory of the Klein case into an application of deterring the government, impeding the government, born of conduct that is not grounded in fraud. So if you take a look, I think Scott was alluding to the Martha Stewart case. She was convicted of lying to the government. It's easy to see that under Section 371, that same kind of conduct could have given rise to say a 371 conspiracy. Scott, you want to comment on that?
Sure. I think, with Martha Stewart, they could have probably charged a Klein conspiracy in addition to the 18 U.S.C. 1001, which is obstruction of justice or lying to a federal official or government agent. And I don't believe they did. I think they just went with the 18 U.S.C. 1001. But you could see sort of similarly to some of the matters we discussed here today, that lying to the SEC about your conduct, about your trading, could impact their regulatory function and safeguarding the U.S. markets. And so you could see how an aggressive prosecutor could charge both of those statutes under Martha Stewart. I mean, I think similarly, Rich, there was a bunch of spoofing cases that were charged a couple of years ago, and that was charged under, I think, the spoofing statute, but also under a wire fraud affecting a financial institution. There, too, you could have probably charged a 371 conspiracy, because when you are engaged in the practice of spoofing, you are then essentially making misrepresentations about whether you're a buyer or a seller of a futures commodity, and the CME is responsible for making sure that the futures trading desks are and the market are not, there's people not committing fraud in those markets. And so you could see how they could have fallen back on a 371 conspiracy there as well.
So, Ellen, if you had to predict, would you say that the Supreme Court may take this case up?
I don't know if this is the right case, but I would say that the time is ripe for the court to re-examine Klein conspiracies, and certainly the idea that the way it has worked has created a much broader interpretation of the word defraud than was ever intended. And with that, we will give you your CLE attendance code, which is SS3 SS3728. Again, it's SS3728.
And S is in Sam. SS. Sam.
So we'd like to thank you all for your attendance today. I hope you enjoyed your sandwiches while you were listening. I hope you got something out of this. Hopefully you're not on the wrong end of a Section 371 claim. But if you are, there's hope. Thank you very much.
Thank you.